Hi, in this video we're going to talk about what a last will and testament is and why it is so important to have one. The last will and testament is the document by which you tell everyone who's going to get what when you die. So that's what the will is. So basically you're saying, I own these properties and I want to give these properties to these people in this manner. So basically that's what the will is. You state your wishes of what's going to happen to your assets upon your death. Very simple. Now, if you think about last will and testament, then we need to be clear, especially here in Florida. Number one, the will is effective upon death. So once you have your will done, you can put the will in the drawer, in your safe deposit box, anywhere. It doesn't matter what it says there today. What matters is how your property will be affected upon your death. So, very important. Your will is effective upon your death. You draft it today, you sign it today, but it's effective when you die. Second, to make a will valid in Florida, you need to have it signed in front of 2 witnesses, and that's it. You don't need the will to be notarized or your signature to be notarized by anyone. However, notarization is recommended by us, the attorneys, because it makes things easier later when you go to prove it. So, but again, to be clear, for a will to be valid, it needs to be signed by you, the testator or testatrix, in front of 2 witnesses, and you all 3 need to be in the same room, watching each other signing in order to be valid. Okay. So one of the things that you instruct in your will is who your personal representative is going to be. The personal representative in Florida is what in other states they call the executor. The same thing, just different names. So the personal representative is the person in charge of doing whatever the will says. So you will grab the will, you will submit it to the judge, and you will file petitions according to whatever stage you are in the probate process. So that's one of the things that you do, because if you don't appoint a personal representative, then the law says, well, these are the order of preference. But if you say who your personal representative is, you need to appoint that person in the will. One of the things that you need to be careful about appointing personal representative is that, for example, you can be a friend who lives in another state. So for a person in another state to be appointed personal representative, that person has to be related to you somehow, by blood, any cousins, situation, of course, son, daughter, whatever, but it has to be related to you. So a friend cannot be appointed personal representative in your will. It has to be a Florida resident if you want your friend to be appointed. One important thing about the last will and testament is that it is your law. So basically you're saying, I don't like what the Florida statute says in this book, and basically I want to state my law. Now the law gives you some limits. For example, you can't disinherit your spouse, because if you disinherit your spouse can come and claim what is called a 30% elective share against your estate. So, I mean, you are running risk. You can't disinherit your spouse. Or you can, but if you do so, your spouse can come and claim 30% of your estate. So that's a better way of saying it. You could disinherit kids if you want to, but you have to say so. You can't just say, I have 3 kids, and you just name 2 kids in the will, and you don't name the 3rd one. That kid is going to say, well, this is not, he forgot about me, so therefore I'm the beneficiary too. The will applies only to your assets owned individually. That's a very important issue that most people don't or are confused about. So the will doesn't apply to any asset that you own jointly, let's say with your spouse or another person, or assets that you own by contract. So let's say life insurance and you have beneficiary designations, or retirement accounts and you have beneficiary designations, or annuities and you have beneficiary designations and things like that, or what is called, if you go to the bank and you put your beneficiaries in a transfer on death clause at the bank, so it doesn't apply to that. So you only, your asset will be affected only if you own the assets individually. So Horacio Sosa owns a bank account in his own name and he doesn't have any beneficiary name in the contract, so therefore that asset will go to probate. Okay, so that's very important. The other thing here that I didn't write, and I think we should write, is that you appoint your guardians of your minor children in this document. So here you state preference on who is going to be the guardians of your minor children, and that way you know and everyone knows who your preference is in terms of who the guardian of your kids should be. Another point about validity of wills, you have to have capacity. I'm not going to get into the legal term of what capacity means, but the law says sound mind. Sound mind means that you have some knowledge of what you're doing in your will. You have to know, or you have to have the capacity to say, well, I own this and I want to give it to this and not to this person, and so on and so forth. So a will cannot be executed by a person who is laying in bed with no knowledge of what's going on in the world. So very important. If a person without capacity signs a will, that will can be contested in court later. So very important. You can't do a will if you are incapacitated. So you have to run it. You have to run to the law office while you have capacity to do a will. So again, two witnesses in front of signing at the same time with you present. Notarization is not a condition for validity, but it makes easy to do the will or to probate the will later in court. So we're going to talk about probate in the next video.